Hello everyone, welcome. Thank you for attending today's webinar, 5 Things You Need to Know When Posting Employees to the Heart of Europe, sponsored by Lydian. My name is Katul Aerts. I'm a Senior Associate in the Employment, Pensions and Benefits practice here at Lydian, and I specialize in international employment. I'm here together with my colleague, Philippe Dereau, who is also a Senior Associate in our Employment, Pensions and Benefits team, and we will be your hosts and moderators during today's webinar. Before we dive into the essence of today's conversation, which I'm sure you're all excited about, let me cover a few housekeeping matters so that you can enjoy our webinar to the fullest. For your best webinar experience, please use a wired internet connection and close other browsers. We are being streamed to your computer, so there is no need for you to dial in. Our interface provides you with control over your own screen, so you can drag and adjust the size of the window to your convenience, and at the right side of your screen, you can find a Q&A box, which you can use if you encounter any technical difficulties. Also, if you have a question on the content of our presentation, you can just type your question in the Q&A box. We will make sure to answer your questions in the coming days after the webinar. For those of you who would like to receive a copy of our PowerPoint presentation, this can be downloaded on a dedicated webpage. We will share the link to this webpage per email after conclusion of the webinar. The entire webinar will also be recorded for your future reference or to share with colleagues. After the webinar, you can download the recordings on the same webpage. And so, without further ado, I will now give the floor to Philippe, who will dive into the actual webinar.
Okay, let's get started. Imagine the following situation. When you get back to work after this webinar, you are informed that for a key project in Europe, 3 key employees within your company have to come to Belgium for a secondment of 18 months. The group of employees consists of 1 American national, 1 British national, and 1 French national. Ideally, all 3 of them can start to work on the 30th of March 2019 in the European headquarters of the group in Zaventem. Needless to say that this is very fast and possibly rather complex. The purpose of today is to give you an overview of everything you should take into account when organizing an international employment situation. It is knocking on an open door, but we have to start with stressing that each and every employment situation is different. The facts are and must be your first point of reference. They will determine quite a lot. In the case we will discuss, 3 employees are posted to Belgium. By posting, we mean that an employee with an employment contract in one country is temporarily sent by his employer to another country to further execute his or her employment contract in that other country. During this period, the employee remains under the authority of his employer. After this period, the employee gets back to his home country. During our explanation, you will notice that there are some variables to take into account. For instance, what is the nationality of the employees? Will they come to Belgium with or without their family? What is their remuneration? And so on. After the webinar, we will send you for your information the questionnaire we generally use to assess an international employment situation.
As the title of this webinar reveals, the focus of today's conversation will be on the 5 things you need to know when posting employees to Belgium. Therefore, it will come as no surprise to you by now that once you've assessed the relevant facts of the situation, we recommend to break the matter up into 5 different aspects, which are work and stay. Is the employee allowed to travel to Belgium, to stay in Belgium and to work on Belgian territory? Which permits are required and how do I obtain these? Employment law. Questions you might have are, will Belgian employment law apply to the posting? And if the existing contractual relationship governed by the law of the home country can remain in place, does the posting require any changes to the employment and salary conditions of the employee? A third aspect you might consider is social security. Which social security legislation applies and where should we pay social security contributions? Do we have to register with the Belgian Social Security Administration? Is there a risk the employee will be insured double or will fall without insurance? Are there any formalities I need to comply with? Taxes. Will the employee become liable to pay taxes in Belgium? And if so, will this mean the employee will be exempt from paying taxes in the home country? Are expats taxed differently in Belgium? and finally, the preparations. Considering all of the above, what should I do to prepare for this posting? Which forms do I need to complete, and when should I do this? Today, we will address all of these topics and provide you with an answer to the questions I have just raised. As promised, we will also show you what this means in practice by referring to the case study Philip has started with earlier during this presentation. First things first, work and stay. As I said, the first thing we will want to assess when posting an employee to Belgium is whether this individual can effectively work and stay in Belgium. The answer to this question will depend on the employee's nationality, the length of their stay in Belgium, and their profession. The main idea is that the Belgian labor market is protected. This means that third country nationals are, in principle, not allowed to work here. If they do wish to do so, they must be admitted to work on Belgian territory and obtain a residence permit to stay on Belgian territory. Traditionally, a difference should be made between the right to stay on Belgian territory and the right to work here. Obviously, the right to work in Belgium implies that you reside in Belgium, although, depending on the situation at hand, a residence permit to actually be entitled to stay in Belgium will also have to be attained separately. As you may know, Belgium is a federal state. The decision to grant third country nationals the right to work in Belgium is taken at the regional level, whereas the competence to decide on the right to reside in Belgium still remains with the federal level. For the purpose of our presentation today, we have assumed that the European headquarters of the company referred to in the case study are located in Flanders. Note that slightly different rules may apply if the host company is located in other regions in Belgium. The general idea, though, is that before granting the right to work on Belgian territory, a so-called labor market test must indicate that no suitable candidate can be found on the Belgian and EEA labor market within a reasonable term, and therefore that it is suitable to grant a third country national the right to come to Belgium and fill up the vacancy. This general rule, though, is rarely applied in practice as numerous exceptions apply to specific categories of people who do not have to pass that labor market test. It regards, for instance, highly educated personnel, executives, etc. As I said earlier, the answer to the question as to whether an employee requires a work and residence permit and which type of permit it regards will depend on a number of elements. The most important one is the employee's nationality. Indeed, the largest category of employees who are exempt from obtaining a work permit are, of course, EU nationals, considering the right of free movement within the European Union. Moreover, the length of the employee's stay in Belgium and their profession are relevant to determine which type of permit is required and what the process looks like to get there. Consequently, a number of possibilities in terms of exemptions, obligations, and possibilities exist, and you will want to assess what the fastest and most efficient way is to have the employee legally work and stay in Belgium. This slide gives you an overview of the different routes in direction of the right to work on Belgian territory. In summary, we can distinguish four specific categories. The first one is a work permit type B. This type of work permit exists several years already and was until recently the most common work permit applied for in practice. It grants the holder of the work permit the right to work for a specific employer in Belgium for a renewable period of 1 year, and important to note is that it regards a work permit only, and thus requires the holding of this permit to obtain a separate residence permit. Through the implementation of the Single Permit Directive in Belgian National Legal Order, a second type of permit, the single permit, has entered into force on the 1st of January of this year. Belgium was considerably late in implementing this directive. The deadline for this to happen was the 25th of December 2013, and the main difference with the previous work permit B is that the single permit provides one permit that allows the holder of the permit to work and reside on Belgian territory. This means that only one process needs to be completed, starting with one application and resulting in one single permit, as the word says itself. The legal initiatives relating to the implementation of the Single Permit Directive have, however, not abolished the Work Permit B that existed already. It has remained in force, but is now limited to employees staying on Belgian territory under 90 calendar days. The third category of permit is the European Blue Card. Attendees from other European countries might recognize it in some ways as a predecessor of the Single Permit Directive. Indeed, it regards the European Union's first attempt to provide in a single permit process to promote the mobility of highly skilled third country nationals and their families within the European Union. Unlike the Single Permit Directive, however, the European Blue Card Directive gave the European member states the option to maintain their existing work permit schemes. Therefore, when implementing the European Blue Card Directive, the Belgian legislature chose to maintain the existing work permit B and just add another possibility for highly skilled workers to obtain a work permit. This possibility exists to date next to the work permit B and single permit, and can thus also be used if the individual concerned qualifies as highly skilled. As a final category, we have mentioned the intra-corporate transfer or ICT-Directive on this slide, which actually has not been implemented in the Belgian national legal order yet. As you may know, unlike European regulations, European directives do not have any direct legal effect and require implementation in the national legal order. The deadline for this to happen has expired since the 29th of November 2016, which makes Belgium late again to adopt the necessary legislation. The actual implementation in Belgium is now expected by May of this year. Before the adoption of the ICT-Directive, it appeared that EU member states had different practices in place regarding intra-corporate transfers and was therefore lagging behind countries such as Japan, Australia, Canada, and the US in terms of inflows of intra-corporate transfers. Therefore, EU policymakers decided to design an attractive EU-wide framework to make the European Union more appealing for multinational companies based in third countries. I will get back on the ICT-Directive and its main provisions in a minute, but before that, I wanted to give you an overview of the current possibilities in terms of obtaining the right to work in Belgium, and, without going into too much detail, summarize the applicable rules per category. As you can see, the overview is split up between a stay of less than 90 calendar days and a stay of more than 90 calendar days. If the employee stays below 90 calendar days, a work permit B should be applied for. If the employee stays over 90 calendar days, he can choose between a single permit and a European blue card. An overall exemption for all categories regards EU nationals. In view of the free movement of workers within the European Union, they do not have to apply for a right to work or stay on Belgian territory. All employees who come to work less than 90 days on Belgian territory should apply for a work permit B, as well as frontier workers and au pairs. Again, a number of categories are exempt from this obligation, and the same exceptions apply for the single permit. The conditions of the work permit and the single permit are more or less the same, whereas the conditions for a European blue card are a bit different. As it regards highly skilled personnel only, the minimum salary threshold is significantly higher, but there is no requirement of a labor market test. And finally, also because of the fact that it regards highly skilled personnel only, a bachelor degree is a prerequisite to obtain a European blue card. Both the work permit B and the single permit should be applied for by the employer, and this before the employee actually travels to Belgium, unless of course the employee is already legally staying in Belgium. It regards, for instance, highly skilled personnel or executives. The European blue card, and although it was intended to be a one-stop procedure, still requires 2 steps. The employer has to apply for a provisional work permit before the employee travels to Belgium. And once the provisional work permit is obtained, the employee can already start working on Belgian territory, provided that he has requested the European blue card on the basis of this provisional work permit already. The process of obtaining a work permit B takes 2 to 6 weeks approximately. For both the single permit and the European blue card, maximum limits apply: 4 months and 30 days plus 90 days for the European blue card. The benefit is that with a European blue card, an employee can already come to Belgium after 30 days, whereas for the single permit, the entire procedure of 4 months must have been concluded first. The necessary documents generally are a copy of a valid passport or equivalent travel document, as well as the employment contract. Various other documents are required depending on the category of permit that you want to obtain. In case of a negative decision, an appeal is possible for all 3 of them. And in the end, the permit allows the employee to work on Belgian territory. Yet significant differences exist. A work permit type B allows to work on Belgian territory with a specific employer for a renewable period of 1 year. A separate residence permit, in the form of a short stay visa, is, however, required as the case may be. Note that there is a list of countries, including, for instance, the United States of America, whereby citizens of those countries are exempt from the obligation to obtain a short stay visa. The single permit allows the employee to work on Belgian territory with a specific employer for a renewable period of 3 years. No additional residence permit is required, as a single permit allows the employee to both stay and work on Belgian territory. The European blue card, in the end, allows the employee to work for a specific employer on Belgian territory for a renewal period of 13 months. A first renewal will result in an additional title for 13 months, And as opposed to the single permit, a second renewal will result in the right to work on Belgian territory for any employer. Again, no separate residence permit is required, as the European Blue Card allows the employee to both work and stay on Belgian territory. Note that in all three cases, and also for people who are exempt from the obligation to obtain a permit to work and stay on Belgian territory, specific registration duties apply when arriving in Belgium. As those are a mere formality and quite easy to go about in practice, we will not elaborate further on these. Considering what I explained just now, and assuming that your employee does not qualify for any exemptions and should thus obtain a work permit or similar permit to work on Belgian territory, you will notice that quite some time is required to obtain those necessary permits. An employer must plan ahead and should consider several months to complete the aforementioned processes. Moreover, in most, if not all cases, documents will have to be collected prior to initiating the process, which will require another couple of weeks or even months of preparation. For instance, an American employer who wants to apply for a single permit should, amongst others, provide a copy of the certificate of coverage. Obtaining this document will take up quite some time, and whereas the administration used to accept the mere proof that you were in the process of obtaining such certificate of coverage, this is no longer accepted and your application will be considered inadmissible without it. Therefore, it is of the utmost importance to try to optimize this process by looking at combinations of specific permits, and we have assessed two possible options. Firstly, the employer could choose to apply for a work permit type B first. With just a little streak of luck, this will take only 2 weeks, and if the home country appears on the list of visa-exempt countries when traveling to Belgium, your employee will be able to travel to Belgium already and start working within little over 2 weeks. Simultaneously, you can then apply for the single permit to ensure that the individual can stay and work here once the short term has expired. Another option would be to choose the European Blue Card, provided that your employee qualifies as highly skilled and earns over a specific amount of money per year. In that case, you can request a provisional work permit, which will be delivered to you with a maximum period of 30 days, after which the employee can again already start to work on Belgian territory prior to actually obtaining the European Blue Card. The benefits of European Blue Card versus a single permit are that the European Blue Card is faster. Moreover, the employee is sure to be able to start working in Belgium after 30 days once the provisional work permit is obtained, whereas there is no maximum limit for obtaining a work permit B. In some cases it might be faster, but there is definitely no guarantee. Secondly, upon the second renewal, the European Blue Card provides the employee with the right to work for any employer in Belgium, whereas a single permit only allows the employee to work for a specific employer. The ICT-Directive creates a residence permit with work authorization for third country nationals and their family members who intend to stay in the EU for more than 90 days in the framework of an intra-corporate transfer. The scope of the directive covers foreign national managers, specialists, or trainees who are transferred from a company outside the EU to an entity of the same undertaking or group of undertakings inside the European Union while staying on their home country employment contract, and who reside outside the European Union at the time of application. An example would be the case of a U.S. national residing in the U.S., working for a U.S. entity of a multinational company, and sent to work for a different entity of the group in Antwerp for 2 years. As said, the ICT-Directive has not been implemented in Belgium yet, but it is expected in May 2019. Once relevant legislation becomes effective, Belgian authorities will have a maximum of 90 days to issue the ICT permit, which should in principle be applied for before becoming to Belgium. The directive also allows member states to simplify the procedures for employers that are recognized for this purpose. The simplified procedure should at least include less strict document requirements and a fast-track procedure for issuance of visas. The ICT permit may be issued for a maximum of 3 years for managers and specialists, and for a maximum of 1 year for trainees. After this, the permit holder must leave the EU, unless they can obtain another residence permit on the basis of national or EU law. This provision ensures that the transfer is temporary and excludes applicants from applying for EU long-term residency. Member states may introduce a cooling-off period for a maximum 6 months after the initial 3 or 1 year period, before the transferee can obtain another ICT permit in the same country. The most notable aspect of the directive is a set of groundbreaking intra-EU mobility rights that simplify the immigration formalities for transferees performing work for different entities of their employer in multiple member states. You will have noticed by now that the biggest category of people who are exempt from the obligation to obtain a work permit in Belgium are EU nationals. In view of their right to free movement, they do not have to apply for any specific permit and are automatically entitled to work on Belgian territory. Considering the timing of our webinar, this exemption ultimately brings us to the question, what about British nationals after the 29th of March 2019? In the assumption that Brexit will still take place, and in the likely scenario that we are heading for a no-deal Brexit, the Belgian government is in the process of adopting legislation that will allow British nationals who currently already reside in Belgium to continue to stay and work here. In 2017, the number of British nationals estimated to work on Belgian territory were around 21,000. And to avoid that those British nationals would have to immediately dispose of a work permit as of the 30th of March 2019, the new legislation aims at granting these individuals the right to continue working here until the end of 2020. Do note that it regards British nationals who reside on Belgian territory before Brexit only. British nationals who will come to work in Belgium after Brexit will be considered third country nationals who will have to apply for a single permit or, if applicable, a European blue card, assuming of course that they will come to work here for more than 90 calendar days. This initiative is based on the assumption that the British government will provide in a similar right for Belgian nationals currently residing and working on British territory. If there is a lack of reciprocity, the draft bill that was submitted in Parliament on February 19th explicitly provides in the possibility to limit the scope of this legislation. If we apply the above principles to our case study, this means the following for a secondment of more than 90 days. In terms of work and stay, you should not be too concerned about the French national. He's automatically entitled to stay and work on Belgian territory in view of his right to free movement. Upon arrival in Belgium, he will have to register with the town hall, but as mentioned earlier, this is a mere formality. For the British national, you need to be slightly more concerned, as Brexit is approaching fast. Ideally, the British national would make use of his right to free movement and move to Belgium before Brexit. After the 30th of March 2019, and provided that he is not yet on Belgian territory by then, he will be considered a third country national and will have to go through the same process as a citizen of the United States. Indeed, the American must apply for a single permit or a European blue card prior to coming to Belgium. We have already explained how you can speed up the process by either combining the work permit B and simultaneously applying for the single permit, or choose to make use of a European blue card and starting to work with the provisional work permit obtained after 30 days.
Okay, employment law is the next topic to tackle. As an introduction, two rules of thumb that may sound complicated, but that will become clear on the next slides. The first one, parties can choose the applicable employment law to their employment contract, but the mandatory provisions of the objectively applicable employment law prevail if they are more beneficial to the employees. The second one, when employees are posted, some hardcore provisions of the host state must be complied with. The next two slides elaborate on the applicable national law on employment contracts. They are relevant for all employment contracts with an international element, not only for posting employees. The slides 3 to 7 are specifically for posting. Which national labor law applies on employment contracts is of course very important, as national labor law governs a large part of the employment relation between employer and employee. As you see in the heading of the slide, private international law is for European situations governed by a regulation, the so-called Rome I regulation, which makes things easier as the rules are the same for everyone in an intra-European context. If we cross the borders of the European Union, we have to look at the private international law of each impacted country. For instance, in case the US national lives and works in the US before he is posted to Belgium, the private international law of Belgium and the private international law of the US will be relevant. It is possible that both will conflict, which then leads to rather annoying situations. For Belgium, it's easy. The Belgian Private International Law Code entirely refers to the rules in the Rome I regulation on employment contracts, so the next two slides are, at least from a Belgian perspective, both relevant, both inside and outside the European Union. As a general rule, parties to an employment contract can freely choose the applicable law, but the employee may not be deprived of the protection offered by the mandatory provisions of the objectively applicable employment law. So that's rather complex. We do it again. As a general rule, parties to an employment contract can freely choose the applicable law, but the employee may not be deprived of the protection offered by the mandatory provisions of the objectively applicable employment law. What is then this objectively applicable employment law? It is the employment law that would apply to the employment contract when no explicit choice of law has been made. This is, in principle, the law of the country in or from which the employee habitually carries out his work. But if this country cannot be determined, it is the law of the country where the place of business through which the employee was engaged is situated. But in any case, when the contract is more closely connected with another country, the objectively applicable law is the law of that other country. If this is the first time that you hear these criteria, you could remark that they seem to be rather vague. Therefore, do note that there is a lot of case law of the European Court of Justice that makes them more concrete, and please also note that these rules are only the basic rules and that there are also some additional specific rules. But what is important for today, that is that the concept of mandatory provisions is very large. For Belgium, it is almost the entire employment law, not to say the entire employment law that really matters. In other words, in case there would be a choice of law clause in the French, in the UK, and in the US employment contract for French, UK, and US employment law, while it would appear that the employment contract is habitually carried out in Belgium, the employees can then ask the application of the mandatory provisions of Belgian labor law that are more beneficial for them. However, what is also important for today, that is that the country where the work is habitually carried out, which is, as said, the criterion to determine which national labor law is the objectively applicable labor law, shall not be deemed to have changed if the employee is temporarily employed in another country. In other words, in case the French, the UK, and the US employee work in France, the UK, and the US, the objectively applicable labor law will in principle be the French, the UK, and the US labor law, and the 18-month secondment to Belgium will not have an impact on this. So the mandatory provisions of Belgian law will not prevail in that situation based on the Rome I regulation. Does this now mean that the Belgian labor law is not relevant for the case? No, not at all, because the employees are posted to Belgium. Belgian labor law almost becomes entirely applicable on the employees. This is, of course, in full contradiction with our conclusion on the previous slide, but no worries, it will become clear. The reasoning for this turnaround starts with the Posted Workers Directive of 1996 that can be seen as a kind of deviation from or a correction on the Rome I regulation. The directive applies to posted workers. These are workers who, for a limited period, carry out their work in the territory of a member state other than the state in which they normally work. And according to the directive, the so-called hardcore provisions of the host member states must be applied to these posted workers, irrespective of which labor law applies. In other words, the hardcore provisions of Belgium must be applied to the posted French, UK, and US nationals. Which are these hardcore provisions? Well, they are exhaustively listed in the directive, such as minimum wages, maximum work periods, and minimum rest periods, minimum paid annual holidays, and so on. The second step in the reasoning is the Belgian Act of 5 March 2002 that converts the directive into Belgian law. Contrary to regulations, as Rome I regulation, directives must indeed be converted in national legislation, and although the member states have some margin of maneuver to convert a directive, the Belgian legislator went extremely far. Indeed, instead of limiting the provisions to be complied with to the hardcore provisions listed in the directive, the Belgian legislator created an open norm by deciding that all criminally sanctioned Belgian working, remuneration, and employment conditions must also be applied to posted workers. This implies that almost the entire Belgian employment legislation should be complied with apart from the Employment Contracts Act. It does, for instance, concern the wage scales on industry level, working time legislation, but also legislation on well-being at work, and so on and so on. Please note that, in practice, there is an important nuance. Indeed, the Belgian Social Inspection realizes that the Act of 2002 goes too far compared to the directive, and in reaction, because they fear to be criticized by the European Court of Justice, they only verified compliance with the hardcore provisions in the directive in case of an inspection. Does this now mean that the Act of 2002 is not relevant anymore? No, not at all. Individual employees can always claim compliance with the Act of 2002 via a court case, but more important, the Posted Worker Directive has been modified very recently, in 2018, and is now getting closer step by step to the Act of 2002. The main changes of the new Posted Workers Directive are summarized on this next slide, and in the changes 1 and 2, you will see that the hardcore provisions have been extended. Instead of only the minimum rates of pay, all the mandatory elements of remuneration must be applied to posted workers, and also the rules of the receiving member state on workers' accommodation and allowances or reimbursement of expenses during the posting assignment must be applied to posted workers. The third important change is that after 12 months, posted workers are entitled to an extended set of terms and conditions of employment of the receiving member state, and this period of 12 months can, after a reasoned submission, be extended to 18 months. This extended set of terms and conditions concerns all employment terms and conditions which apply on a mandatory basis in the receiving member state, in our case Belgium, with the exception of conditions and procedures regarding signing and terminating employment contracts and additional pension schemes. Okay, so as mentioned on the previous slide, the hardcore provisions have been extended in an important way. Posted workers will, on the basis of the new directive, be entitled to the same remuneration as local workers for the same work on the same place. It is the receiving member state that has to determine what remuneration is, but in any case, must all mandatory remuneration elements be included and not only the minimum wages. Allowances specific to the posting may be included in the comparison unless they cover expenses actually incurred on the account of posting. Think about travel, board, and lodging. On the previous slide, we elaborated on the extended set of rules that apply after 12 or 18 months, and we explained that it concerns all employment terms and conditions which apply on a mandatory basis in the receiving member state, with the exception of conditions and procedures regarding signing and terminating employment contracts and additional pension schemes. As this is very large, you could see this as a de facto limitation of posting workers to 12 or 18 months. And then the last topic for this slide is an information obligation for the member states. Indeed, the member states will have to make an official website on which they publish information on the terms and conditions of employment and remuneration in their member state, so that employers who post workers to the member state know what to do. In Belgium, such website already exists. And then the last slide on employment. The transport sector remains outside the scope of the directive. For the transport sector, a separate set of rules will be worked out in the so-called mobility package. The directive must be implemented on 30 July 2020 at the latest, but one of the main questions is whether a lot will change for Belgium or not. Well, most likely not, as the directive is, as explained, getting closer to the Act of 2002. But of course, the social inspection will likely become more severe. As explained, the social inspection does not fully enforce the Act of 2002, as it is too large. And with the new directive, that has become larger too, they will likely align with the new directive. Then the last question, will Brexit have any impact? Well, the answer is very easy. No, as the Act of 2002 is not limited to intra-European postings. Let's change voices again so that you don't fall asleep.
The third aspect you should consider is social security. Where will the employee be socially insured during the time of posting, and where should the employer pay social security contributions? The answer to this question breaks down in two possibilities. Either the employee is being posted from within the European Union, or he's being posted from outside the European Union. For over decades, social security systems within the European Union are being coordinated by a social security regulation. The latest was adopted in 2004 and is referenced to on the slide. Along with the regulation, a so-called implementation regulation was adopted that provides him further clarity as to the application of the rules. It is important to note that it regards coordination and not harmonization. This means that the regulation does not align the different national social security legislations. It just points out which national social security legislation is applicable to a cross-border employment situation. For postings from outside the European Union, it should be verified whether there is a bilateral treaty between Belgium and the home country. Such bilateral treaty basically has a similar purpose as the European regulation and will for each specific scenario of cross-border employment point out which social security system should be applied to avoid employees being insured twice, and employers, of course, having to pay contributions twice, as well as to avoid that employees fall outside the scope of both national legislations and remain uninsured. It is generally possible that for a scenario of posting from outside the European Union, there is no bilateral treaty. Currently, Belgium has concluded bilateral treaties with 25 countries, all of which are listed on the website of the Social Security Administration in Belgium. In case there is no such bilateral treaty, the aforementioned risk of double insurance or no insurance at all remains and will depend on the application scope of the internal legislation of the countries involved. For postings from Belgium to a country outside the European Union, a specific safety net was created, the so-called overseas social security, allowing Belgian residents to remain socially insured while posting to a country with which no bilateral treaty is concluded. It should be verified whether a similar safety net exists for third country nationals posted to Belgium in their respective home country. As said, within the European Union, the goal of the regulation on coordination of social security systems is to determine which national social security system is applicable against the general idea that only one social security system can be applied in a cross-border situation. As said, this is to avoid double insurance or no insurance at all. Each member state remains competent to decide on the rules of its own social security system, but it cannot deny access to a foreign national who, based on the rules set out in the regulation, should be socially insured in that member state. The general rule is that an employee is socially insured in the member state where he or she works. This is the so-called work state principle, which of course poses problems in a cross-border situation where an employee works in more than one member state. Therefore, two exceptions to this general rule exist, one of which is a scenario of posting, the other of which is split employment. The latter relates to a situation where an employee continuously works on the territory of two member states. An example would, for instance, be a Belgian national who works for a Dutch company with a branch office in Flanders. This scenario falls outside the scope of our presentation today, but the first exception is the one that relates to the situation of posting, our topic of today. Indeed, in a scenario of posting, the employee is still working in one member state at the same time, but is only doing so for a very short period of time. Afterwards, the employee will in principle return to the home country. Therefore, and provided that certain conditions are met, the regulation states that in case of posting, the employee remains socially insured during the period of posting. When making use of one of both exceptions, employers are required to obtain the so-called A1 form. This is a standard form delivered by the Social Security Administration of the competent member state to confirm that an employee is socially insured in that specific member state, in compliance with the rules set forth in the regulation. The regulation exists for quite a while now, and case law of the European Court of Justice has continued to clarify and specify the rules and how they should be applied in specific cross-border scenarios. Moreover, practice has evolved and loopholes were found. On the basis thereof, voices were raised to amend the text of the regulation accordingly, and more in particular with regards to the following topics: the definition of secondment, the binding nature of the A1 form and which process the member states should follow if they believe the A1 form was delivered in breach of the rules of the regulation, Modifications to the adjustment system of social security contributions is a third and final one. These changes are laid down in a draft text which is expected to be approved during a plenary meeting of the European Parliament, the European Council and the European Commission on the 16th of April of this year. The current version of regulation provides a specific definition of posting, and the posting exception goes as follows. A person who pursues an activity as an employed person in a member state on behalf of an employer which normally pursues or carries out its activities there, and is posted by that employer to another member state to perform work on that employer's behalf, shall continue to be subject to the legislation of the first member state, provided that the anticipated duration of such work does not exceed 24 months, and that he is not sent to replace another person. As you will notice, the definition contains several elements, some of which are subject to change in the draft amendment of the regulation. First of all, the employer himself must have substantial activities in the sending state. Hence, the posting scenario may not have been created to avoid the work state principle and make use of a foreign and perhaps cheaper social security system. For the same reasons, the current version of regulation requires the employee to have been subject to social security legislation of the sending state immediately before the start of the secondment. The text of the regulation does not clarify what is meant with immediately, but the practical guide of the Administrative Commission clarifies that it regards a period of at least 1 month prior to the secondment. The draft amendment of the regulation now explicitly foresees in a minimum duration of 3 months to be included in the text of the regulation itself. Secondly, after expiry of the maximum duration of posting, the posted employee cannot be replaced by another employee who is, on his or her return, posted from the home country in application of the secondment exception. This again is to avoid that the posting exception is used to circumvent the general work state principle by calling upon different employees who will essentially perform the same job under the pretext that they are actually posted. The idea is to change the regulation so that with replacement is meant replacement by another employee, but also replacement by an independent contractor. A similar exception applies for independent workers who can also, just like employees, be seconded from one member state to another while remaining socially insured in their home state. It goes without saying that replacing an employee who is temporarily seconded by an independent contractor who performs the exact same job is also a way of circumventing the work state principle, which is not allowed. Finally, the draft text provides in shortening the maximum duration of posting from 24 months to 18 months, in line with the new Posted Workers Directive as explained earlier by Philippe. The second modification to the regulation that is currently on the table relates to the A1 form. As said, an A1 form is a standard form delivered by the Social Security Administration of the competent member state to confirm that an individual is indeed socially insured in that member state in line with the provisions of the regulation. An A1 form is binding upon the Social Security Administrations of other member states until it is withdrawn or cancelled by the Social Security Administration that issued it. This means that the A1 form protects the employer from claims of foreign Social Security administrations should they be of the opinion that the rules of the regulation are not applied correctly. If the Social Security Administration of one member state does not agree with the A1 form delivered by the Social Security Administration of another, the member states should contact each other and sort things out between them. Consequently, the A1 form is of the utmost importance and provides some significant protection for the employer and employee. In practice, however, the binding nature of the A1 form was the object of debate numerous times. More in particular, in case of fraud or in case of manifest errors, not all member states are apparently that meticulous and diligent when issuing A1 forms, the question was raised whether the binding force of the A1 form would still prevail. It would go beyond the scope of this webinar to go into the case law in further detail, but in any event, it has resulted in some proposals to amend the regulation. More in particular, it regards the explicit mention that the A1 form must be fully completed for it to have binding power, and secondly, the entry into force of a specific dispute proceedings between member states and the possibility for the national judge to discard a fraudulent A1 once these proceedings have been concluded. The last change foreseen to the current text of regulation is to provide a direct compensation mechanism between member states in case of undue payment. For instance, let's say a French employer pays French social security contributions for an employee who is working and living in Belgium. After a while, all parties concerned find out that actually the Belgian social security legislation should have been applied and that for a number of months undue payments were received by the French Social Security Administration. In the current text of the regulation, the employer should immediately and retroactively pay Belgian Social Security contributions to the Belgian Social Security Administration and can, at its own initiative, ask for reimbursement of the undue payments in France, insofar, of course, the statute of limitation has not been reached yet. The new version of the regulation would make it possible for member states to compensate this directly, so that the French Social Security Administration pays the undue payments to the Belgian Social Security Administration without having to go through the intermediary of the French employer. This is, of course, to ensure payment of the competent Social Security Administration and to avoid that the French employer, in our example, would keep the money reimbursed by the French Social Security Administration without paying the Belgian Social Security Administration itself. This direct compensation system between member states existed already for benefits of Social Security granted by one member state, but actually due by another. In the same draft Brexit Act as referred to earlier, which was submitted to Parliament in February of this year, a specific chapter is dedicated to the Social Security of British nationals. Until the 31st of December 2020, the United Kingdom will be equated with a member state in the sense of the regulation on coordination of social security systems. Again, this initiative is based on the assumption that the British government will provide in a similar provision in favor of Belgian nationals working on British territory. Moreover, it explicitly foresees that cooperation of the British National Administration or National Insurance Administration is expected, and that the Belgian Social Security Administration can discontinue to equate the United Kingdom with a member state of the European Union in case the British Social Security Administration fails to cooperate in providing the necessary information within the requested deadline. If there is a lack of reciprocity, the draft bill provides a possibility to limit the scope of this legislation. And then finally, if we apply the above principles to our case study, this means the following. The French national remains socially insured in France, considering all conditions of this continent in the sense of European regulation are met. Also, the British national will remain socially insured in the UK, as the UK will be equated with a member state of the European Union until the end of 2020. For the American national, we must assess whether there is a bilateral treaty between Belgium and the United States of America. This is the case, and in this particular instance, the American citizen will continue to remain socially insured in the United States of America, considering the period of posting is below 5 years. This is the maximum duration of posting as provided for in the bilateral treaty.
We're almost there, the taxes. Yes, we are employment lawyers, but we know something about taxes too. What you see here, or what you will see here, is an outline of Article 15 of the OECD Model Tax Convention. Contrary to the previous topic, there are no European rules on income taxes. But for international situations, the OECD, that is the Organization for Economic Cooperation and Development, has drafted a model convention to avoid that income is taxed in more than one country. The document is a model for bilateral conventions, and it is used on a very large scale. So when the model is used between two countries, it determines which state may tax a specific income and which state has to exempt the income from taxation. Article 15 of the model does this for employee remuneration. And according to this Article 15, the residence state may tax income except for income from employment exercised in the other state. Income from employment exercised in the other state may be taxed in that other state, the work state. On this general principle, there is an important exception. Indeed, income from employment in the other state is nevertheless taxable in the residence state if the following conditions are fulfilled. First one, the presence in the work state does not exceed 183 days in any 12-month period commencing or ending in the fiscal year concerned, and the remuneration is paid by or on behalf of the employer who is not a resident of the work state, and the remuneration is not borne by a permanent establishment which the employer has in the work state. We know it is almost impossible to understand this clause, and the reason is that the exception only applies if three negative criteria are cumulatively fulfilled. The clause is easier to understand if we turn the clause around, being Income from employment is only taxable in the work state if the presence in the work state exceeds 183 days in any 12-month period commencing or ending in the fiscal year concerned, or if the remuneration is paid by or on behalf of the employer who is a resident of the work state, or if the remuneration is borne by a permanent establishment which the employer has in the work state. If we apply this to our case, we see that both for 2019 and for 2020, our 3 employees will most likely be more than 183 days in Belgium in a 12-month period commencing or ending in the fiscal year concerned. So, due to this simple reason, the remuneration for the work in Belgium will, according to the model, be taxed in Belgium and exempted in France, in the UK and the US. However, it would be a classic mistake to solve the case based on the model convention. The model convention is indeed only a model, so it is, and we have to stress this, very important to check the individual double tax conventions, as every convention can be slightly different. And this is what we see on this next slide. Indeed, in the Belgian-French treaty, the 183 days must or may not, depending on what we want, be reached during a calendar year instead of during any 12-month period commencing or ending in the fiscal year concerned. This is a substantial difference with the OECD model. In the Belgian-UK treaty, the 183 days must or may not be reached during any 12-month period, and in the Belgian-US treaty, the same text as in the OECD model is included. To give an idea of the differences, imagine that the 3 employees only come to Belgium in October of 2019. And let's assume that the remuneration is not paid by a Belgian employer, which will indeed not be the case as the employees have their employer in France, the UK and the US. And let's also assume that the remuneration is not borne by a permanent establishment of these foreign employers in Belgium. Well, in that case, the remuneration for the work in Belgium in 2019, so for 3 months, October, November, December, will not be taxable in Belgium for the French employee, as he or she will not have been in Belgium for 183 days during calendar year 2019, but for the UK and the US employee, the remuneration for the work in Belgium will be taxable in Belgium. As correctly mentioned on the slide, there is no Brexit impact as the European Union is not relevant for this topic. The second tax topic for today is the Belgian special tax regime for foreign executives. As the name suggests, this tax regime is not for everyone, but for the eligible employees it can be very beneficial, of course only if Belgium may tax remuneration. The slide lists the conditions to be eligible for the special tax regime. The employees concerned should be non-residents with a foreign nationality who temporarily perform a function in Belgium, and this function must be a leading function with a particular knowledge and responsibility in a foreign company or in a company under foreign control. Temporarily perform a function in Belgium is a very flexible concept. There are even examples of employees who still benefit the special tax regime after 20 years in Belgium, and the education, experience and annual salary of the employees can be an indication of the particular knowledge and responsibility. Employees who have just graduated or who have a purely administrative function will not be eligible for the special tax regime. The advantage of the regime is that the employees remain non-residents. This has 2 major consequences. Firstly, the foreign executives are only taxable on income for their work effectively performed in Belgium, as well as other income of Belgian origin. This also means that they are not taxed on their income for travels abroad. This is the so-called foreign travel exclusion. So, for instance, executives who are on business trips abroad for 20% of their time will in Belgium not be taxed on this 20% of their income. The foreign executives can also be granted a lump sum tax-free cost allowance of €11,250 because the Belgian tax authorities consider that being an expat in Belgium leads to additional costs for the employees, such as a higher tax rate, travel costs, school fees for the children, and so on. The application of the special tax regime must be filed within 6 months as from the first day of the month following the start date of employment in Belgium. And as a last topic, we must warn that although the special tax regime seems to be very interesting, it is important to be careful and to make proper calculations in advance compared to not applying this regime. Indeed, too many travel exclusions can, for instance, lead to the loss of certain other tax advantages the employee would have if he would not have applied for the special tax regime. That were the taxes, which brings us to the last topic.
Yes, the last thing on your list is to make sure that you have a clear step plan to prepare the actual posting to Belgium. As you can see, our step plan consists of 3 time slots: prior to departure, prior to the start of activities, and after arrival. Prior to coming to Belgium, you should obtain the relevant permit for the employee to work and stay in Belgium. You should also obtain an A1 form if you are posting from within the European Union, or check the bilateral treaty and obtain the relevant forms if you are posting from outside the European Union. Finally, you should conclude an assignment letter or agreement to make sure all conditions of employment during the assignment are contractually agreed upon. This assignment letter can provide in a clear choice of law, can stipulate the mandatory provisions that will be complied with, and can of course contain all other types of contractual agreements such as a tax equalization, a return clause, etc. Prior to actually starting work, and this is a formality we have not yet touched upon earlier in this presentation, you should make sure to do a so-called Limosa declaration online. Basically, this is an online tool allowing the Belgian Social Security Administration to have an inventory of foreign workers currently employed on Belgian territory. Therefore, any individual not subject to Belgian Social Security who comes to work in Belgium on a temporary and/or part-time basis must be able to present proof of this Limosa declaration. Failure to make this declaration exposes the employer, but potentially also his client and the host company, to criminal and administrative sanctions. Filing in the Limosa declaration is pretty straightforward. It also simplifies the employer's administrative obligations in Belgium, such as being exempt from drawing up certain social documents, such as payslips and staff registers, for the first 12 months of employment in Belgium. And lastly, when arriving in Belgium, you should consider registering with the town hall of the municipality the employee resides in, and make sure you put in place the necessary arrangements in view of your tax liabilities during the assignment.
And then, instead of summarizing the 5 topics in a way too large conclusion, we have listed 4 takeaways. For work and stay, plan ahead. Depending on several variables, it can take some time before someone can come to Belgium. For employment law, compare the remuneration package of the employees to the required remuneration package in Belgium. For social security, the duration of the secondment is important to stay under the foreign social security regime. And for taxes, it is recommended to check whether the special tax regime for foreign executives can be advantageous. That was it. We want to sincerely thank you for attending this webinar. It was our pleasure to be your host today, and we hope to welcome you soon on a next occasion. Do not forget to download the presentation by clicking on the link we will send you shortly after this webinar. Should you have missed a part of the webinar, or should you want to look at it again, you will also find a recorded version. Please do not hesitate to share our presentation with anyone you might think be interested. Bye.